Hello and welcome to The Print. This is Khadija Khan from New Delhi, and today I'm going to tell you about the rarest of the rare doctrine, which is often invoked in death penalty cases. The discussion about this doctrine assumes significance in the backdrop of two very important judgments passed by the Sialda District Court in Calcutta and a local court in Trivandrum. In the Kolkata rape and murder case concerning the state-run RG Kar Medical College and Hospital, the court did not give a death penalty to the main accused Sanjay Roy, citing the rarest of the rare doctrine. On the other hand, citing this very doctrine, the Trivandrum court awarded the death penalty to a 24-year-old woman, Greeshma, for murdering her boyfriend Sharon Raj by poisoning him in 2022. But what is this doctrine and why is it invoked in death penalty cases? Well, according to this well-established principle of law, death penalty can only be given in the rarest of the rare cases where the convict has committed a heinous crime. Now, in the 1980 Supreme Court ruling in Bachchan Singh versus State of Punjab, the court said that while death penalty could be given, it could only be done in cases where there was no possibility of reform or life imprisonment appeared altogether inadequate. The court also came up with guidelines to be kept in mind while granting death penalty. For instance, it said that extreme death penalty need not be inflicted except in the gravest cases of extreme culpability. An offender's circumstances also need to be considered amongst other things, the court said. It also spoke of aggravating or mitigating circumstances. While aggravating circumstances are those that increase the severity of an act, mitigating circumstances are those that lessen the severity of an act. And the court also said that these must be given due weightage. So why didn't the Sialda court give death penalty to Sanjay Roy, who was the main accused in the RG Kar case? Well, in the January 18th ruling, Additional District and Sessions Judge Anirban Das said that modern justice must rise above primitive instincts like an eye for an eye or a life for a life. The judiciary's primary responsibility is to uphold the rule of law and ensure justice based on evidence, not on public sentiment. It is of prime importance that the court maintains its objectivity and impartiality by focusing solely on the acts and evidence presented during the trial rather than being swayed by public opinion or emotional reactions to the case, the court said. Although the court also acknowledged that the manner in which the offence was committed was barbaric and indeed brutal, it found that the case where an on-duty doctor was raped did not fall into the rarest of the rare category, and thus death penalty couldn't be given. Instead, the court sentenced former civic volunteer Sanjay Roy to life imprisonment along with a fine. And it also said that the court's duty is to pass a sentence that is proportionate, just, and in accordance with established legal principles, and that it must resist the temptation to bow to political pressure or emotional appeals. So why did the Trivandrum court then sentence Greeshma to death penalty? Well, according to the prosecution's case, in the October of 2022, Greeshma allegedly murdered her boyfriend Sharon Raj by mixing poison in his herbal medicine. 11 days later, he passed away while being treated in the ICU of a medical college. Now, it was also alleged that Sharon and Greeshma were in a long-term relationship. But Greeshma had planned to marry another person and sought to end her relationship with Sharon. However, when he refused to break up, it led to his murder. The boyfriend's dying declaration to the magistrate also revealed that he had consumed the medicine given by Greeshma without suspecting any harm, and this proved to be a significant factor in the investigation. Emphasizing that Greeshma's act amounted to barbaric and inhuman behavior of the highest order, the court said that the manner in which the murder was carried out was extremely brutal and revolting enough to shock the collective conscience. In its 588-page order, the court relied on the 2003 Supreme Court ruling in Sushil Murmu versus State of Jharkhand, which said, in rarest of the rare cases, the collective conscience of the society is so shocked that it will expect the holders of judicial power to inflict death penalty irrespective of their personal opinion. In that case, the court had also given examples of what circumstances can be considered fit for grant of death penalty, such as when the murder is committed in an extremely brutal, grotesque, diabolical, revolting, or dastardly manner, so as to arouse intense and extreme indignation of the community. And that brings us to an end of today's segment. For more legal updates, keep watching The Print with me, Khadija Khan.